Good afternoon, everyone. It is now 2 p.m. My name is Gabriella Nyman, and I am NCCASA's Training and Communication Specialist. Before we start the webinar, I'm going to just go over some basic webinar logistics. I'm sure most of you have been living on Zoom, but for this webinar, any questions or comments that you have, if you will, please type them into the chat box. And we will either stop and answer them then or wait until a good stopping point to answer them. I'd like to thank you all for coming to our webinar today, Title IX Support for Historically Black Colleges and Universities. I'd like to introduce our two presenters, Sky David, our NCCASA Staff Attorney, and Tracy Wright, our NCCASA Resource Sharing Project Technical Assistance Provider and Women of Color Leadership. I will go ahead and turn over the webinar to them.
Hi, everybody. I'm so glad to see so many of your names popping up in the chat. My name is Tracy Wright, and I work here at NCCASA. In addition to the national TA work that I do, I also support HBCUs in helping them build their capacity in extending culturally affirming entree to resources. And just want to thank you all for being here today, acknowledging that this space is designed solely for faculty and staff and stakeholders at North Carolina's historically Black colleges and universities. And we thank you all so much for being here, understanding that we are existing in dual pandemics, one in response to COVID and one seeing a great deal of unrest with this country's pre-existing condition of racism and oppression that we are all sitting with, and really engaging in a way to be really hopeful because we see our young people organizing in a really different way. So, those are two things that I hope that you all know about NCCASA as the statewide coalition that works to end sexual violence through education, advocacy, and legislation, that our framework and how we approach our work is through a social justice lens. And so really excited that you all will get a chance to spend some time today to learn more about myself as well as Sky, and to talk about the shifts in Title IX regulations and the impact on how those things will show up on your respective campuses. So thank you all so much for being here today. Super, super excited to see the folks in the chat, and I'm not going to talk too much longer because y'all want to hear from Sky. I want to hear from Sky, the amazing Sky David, who I say is the greatest of all time, along with Gabriella, on putting this together, getting this together in a really short turnaround. I love Sky. Sky read the Title IX regulations in one night, party people, 2,000 pages of goodness, and is able to come back to us and share the significant shifts that potentially could impact your campuses. So as Gabriella mentioned, please utilize the chat feature. If we get to a point in the presentation where you all have questions, we will stop then and answer those questions so that we can make sure you all have access to all the information you need. Grateful for each and every last one of you joining us today as we move through the Title IX regulations. And so without further ado, Sky, you ready?
Yes, thank you so much, Tracy. I just want to start again, as Tracy said, I'm Sky David. I am the staff attorney for NCCASA. And I just want to start talking to you all and asking who you are. So you can do that in the chat if you'd like, and just like, what are you feeling today and what brings you to this space? So I'd love to hear from y'all what you want to get out of either the relationship with NCCASA or learning about these regulations. What are you confused about? or just what can we do to support you? So if y'all just want to drop that in the chat, I'll give you a few seconds. Okay, I see knowing my role as a faculty member. Regulations for advocates during live hearings, how changes impact our students. Yeah. I see that Dr. Williams says he feels good today. Eager to learn any new or revised information. Yes. Rewriting our definition of sexual harassment and rewriting Title IX. I know. And as you all know, your new Title IX regulations are supposed to be updated by August 14th. And so I know that seems like it is coming fast and it is a huge undertaking, but we are happy to talk about that with you. Vanessa says, I'm deeply troubled by many elements in the regulations, decrease in students seeking support and justice, but will exacerbate these severe consequences. Yes. Yeah, recommendations. So we'll go through some of that. That is a really comprehensive question, and we will go through a lot of that. And then I should also just say that if you guys, after we finish this webinar, you still have some questions or you want me to take a look at your policy, policy is really my area of expertise. I'm happy to work with your institutions on what you can do if you want to go above the bar that the federal government has set out.
And I think the other thing that it can also be cool too, Scott, is as we move through these conversations is most definitely to highlight some of the work that you have been able to do with campuses and survivors broadly, so that folks are really, really clear about the things that they can access by way of your expertise, by way of NCCASA as well too.
Yeah, thank you. Okay. I will just start by giving a brief overview of what we provide at NCCASA. Like I said, I'm happy to do policy review of your policies. We've had some campuses take us up on that before and have really good working relationships. I will make a quick plug, as I always do, for our campus consortium. If Tracy wants to speak, Tracy, would you like to talk about that a little bit?
Oh, that's a nice alley-oop. Absolutely. Absolutely. NCCASA is in partnership with the North Carolina Coalition Against Domestic Violence, and we host a campus consortium that we definitely invite you all to participate in. And it's a joint effort really to galvanize and bring together all campuses to talk about any emergent needs that we're seeing on our respective campuses, from those within the state system, UNC system of campuses, coupled with community colleges, coupled with HBCUs and private colleges as well. So it's an opportunity for folks to come together and really share resources. A lot of our meetings so far have moved to online, but we also have a pretty robust mailing that goes out once a month with resources, things that both coalitions are reading in response to campus work. So definitely would invite you all to stay connected, get connected with that. I'll drop my email in the chat box. And of course, it'll be available after this Zoom meeting. And so you can all be connected in that way. Absolutely.
Okay, So aside from that plug, we also do and are happy to do on your campus training services. I know with the new regs, you have to post online what training your Title IX folks go through. So we can work that out, but we have been in discussions, Tracy especially has been in discussions with folks about doing like restorative justice trainings and what that looks like for your campuses, if that's an option that you choose to have for your Title IX process. And also we just want to highlight that we do provide pro bono legal counsel for complainants in the Title IX process. So if you're an advocate on campus, please feel free to recommend us to complainants during the process. I should just open this up and say, what services do you feel you need on your campuses or are looking for from NCCASA? We know that folks feel like they don't have enough resources to do all of this work and to do it well. So I know resource sharing is important. And like I said, the Campus Consortium can be helpful for that. But what other resources or services do you feel that we could help you with? Okay, we'll leave that open-ended. I'll go ahead and move on. So I'm just going to get into the Title IX regulations. I'm going to start with a word about language. So survivor, perpetrator language that you often hear from advocates. I use in Title IX language complainant, respondent, or reporting party and responding party, akin to plaintiff, defendant. Most of you, I'm sure, pretty aware of this. And responsible, not responsible would be akin to guilty, innocent. And I always just include that I recognize and understand that there are survivors in all of our workspaces and want to note that I don't use this language to make people feel less important, but just to note it is for consistency. So the process of how we got to where we are right now. So these proposed rules were originally released in November 2018, and 2018 seems so long ago. But the notice and comment period opened thereafter, and the Federal Register extended the time frame. And as a really big note of how important this is, this rule received the most comments in one day than any other rule, for a total of 124,000 comments. And it was the first formal notice and comment process by OCR since 1997. And these regulations do have the force of law behind them. And important to note that the Obama regulations, the Dear Colleague letters, those did not. Advocates have been working for years, these last 2 years, on meetings with ORA and voicing concerns over specific aspects of the rule. And some of those aspects were changed. The final rule was released on Wednesday, May 6th, with an implementation start date of August 14th. But it is important to note that many groups like the National Women's Law Center and Know Your Nine have already stated they will challenge and have challenged the rule in court. So there are a few different lawsuits that are already circulating. And so in a perfect world, this would never go into place. And what will this look like if there is a new administration in the White House next year? That all is up in the air. So while it feels that we do have these finalized rules, there are still many, many things at play. I like to go over some wins because, and as someone noted in this, like the rule is rough. But I do want to go over some things that in earlier versions were a lot worse than the rule. So just to have small points of celebration, as I said, for the last 2 years, advocates have been addressing issues with the rules, and that's both in online comments and during ORA meetings, and some positive changes from previous versions of the rule. Fraternity sorority houses are explicitly included in the final version of the rule, and there is more. I will go into that more later because that's not unofficial fraternity sorority houses, but official ones. are included in the rule, and they weren't previously. The standard of evidence. Previously, the rule said if a school could choose to employ the preponderance of the evidence standard only if that school uses that standard for conduct code violations that do not involve sexual harassment, but carry the same maximum disciplinary sanction. So that was a little more lax than the final rule. And the final rule does state that a school can choose either preponderance of the evidence or clear and convincing, but must use the same standard for employees. And again, as I go along, feel free, if you have questions, just put them in the chat box and we'll try to address the questions. And, you know, if you have a question and it's something I'm going to be covering later, I'll just note that. I'm just going to highlight some of the biggest issues in the rule. These are top line items. One is mandating live hearings by adjudicators who are neither the Title IX coordinator nor the investigator. We know that that can be really difficult at small institutions. The evidentiary standard is allowed to be raised from preponderance of the evidence to clear and convincing. The third big issue is off-campus incidents. Like I said, unofficial fraternity, sorority houses, study abroad programs. If sexual violence occurs in an apartment that is off campus, those types of things. Again, we'll get into all of this. Cross-examination by the party's advisor of choice, removal of that 60-day timeline, narrowing of what sexual harassment is. I think someone noted that in the chat earlier. Mediation, religious exemptions, and the same school requirement. Again, these are my list of some of the biggest issues, and we'll just go through them each individually. So as far as notice to school, in the rule, notice is triggered when, and in the K-12 context, allegations of sexual harassment have been disclosed to any employee of an elementary or secondary school. And in North Carolina, that does trigger mandatory reporting. But in the campus setting, the rule allows for flexibility to decide who's a mandatory reporter on campuses, or to designate some employees as confidential resources to discuss without triggering that Title IX report. I think somebody maybe mentioned that in the chat earlier as well. In both K-12 and campus settings, once a Title IX coordinator or an official with authority to institute corrective measures on the school's behalf. And that line right there, what does that mean? That is up to the institution to decide. But once they have knowledge of an allegation, it does then trigger the school's response obligations. Another issue, the deliberate indifference standard. And so this is something that I would say is more favorable to schools than before. So if you are on a campus, that could be seen as a positive. From an advocate standpoint, it's not, but from a school standpoint, it could be. So schools must respond to sexual harassment in a way that is not, quote, deliberately indifferent, which means that it's not clearly unreasonable in light of the known circumstances. So what schools must do is provide supportive measures to the reporting party, not restrict rights such as the First, Fifth, or 14th Amendment, respect the reporting party's wishes as to whether the school investigates. And if allegations don't meet the standard in the rule for sexual harassment, or they don't occur on campus or not within the educational program or activity, the school would not have these obligations. Another issue is the religious exemption included in the rule. There is a specific exemption for religious institutions to be exempt from Title IX obligations. And it is done by the school submitting in writing to the assistant secretary a statement by the highest ranking official of the institution, identifying the provisions of this part that conflict with a specific tenet of the religious organization. So what does that mean? A school can religious exemption at any time and without approval from the education department. So they can tell the student that we're exempted because of this religious exemption, and then later submit that exemption to the Department of Education. And if the school does exert that exemption, but hasn't filed with the education department, and then comes under investigation for noncompliance, they can raise that exemption at any time. So it's fairly flexible. And the previous guidance was that any campuses that received funding, K-12, college campuses, et cetera, they were all included in Title IX obligation. All right, here's a really big bucket of work in this finalized rule, the location of the violation. So the Title IX statute applies to persons in the United States with respect to education programs or activities that receive federal assistance, and that in the United States is really important here. The final rule states that schools must respond when sexual harassment occurs in the school's education program or activity against a person in the US. And it does include locations, events, or circumstances over which the school exercised substantial control over both the respondent, the context in which the harassment occurred, and includes buildings owned or controlled by a student organization that's recognized by the school. So that's that part that pulls in fraternities, sororities, etc. It does limit violations at a particular school to only students at that institution. So if you have two schools that are beside each other and the respondent is from a different school, those would no longer qualify under Title IX. However, schools may address sexual harassment that's outside their jurisdiction by any manner the school chooses, such as supportive measures or discipline. Maybe you could bring a violation of your code of conduct, but it wouldn't be a Title IX violation. The definition of sexual harassment, the final rule defines sexual harassment to include any of three types of conduct on the basis of sex, all which jeopardize the equal access to education that Title IX is designed to protect. Any instance of quid pro quo, any unwelcome conduct that a reasonable person would find so severe, objectively offensive that it denies a person equal educational access, and any instance of sexual assault defined in the Clery Act, dating violence, domestic violence, or stalking as defined in VAWA. The final rule does prohibit sex-based misconduct in a manner consistent with the First Amendment. Quid pro quo harassment and Clery Act VAWA offenses are not evaluated for severity, pervasiveness, offensiveness, or denial to equal educational access, because that conduct the education department considers sufficiently serious to deprive them of that equal access. So it doesn't have to be held to that same standard. The previous guidance defined sexual harassment as unwelcome conduct of a sexual nature. So as you can see, that included unwelcome sexual advances, requests for sexual favors, and other verbal, nonverbal, or physical conduct of a sexual nature. It was super, super broad, and that was one of the complaints I think that the education department received from schools and from a lot of like pro-respondent groups, that was just too broad. The positive in this is that stalking was not included in previous guidance and now is in the rule, and so that's statutory. Continuing with sexual harassment, they use the Supreme Court's Davis definition, the severe and pervasive, objectively offensive, as one of the three categories of sexual harassment. So that where unwelcome sex-based conduct consists of speech or expressive conduct, schools balance Title IX with respect for free speech and academic freedom. If you've been following, and I'm sure you all, because you work in this field, have been following Title IX cases throughout the last few years, lawsuits, that's something that you heard a lot come up, you know, free speech rights, etc. And the final rule uses the Supreme Court's Title IX specific definition rather than Title VII workplace standards. The First Amendment concerns differ in education environments, and the Title IX definition provides First Amendment protections appropriate for educational institutions where students are learning and employees are teaching. Students, teachers, faculty, and others should enjoy free speech and academic freedom protections even when speech or expression is offensive. This comes from the rule. This is not my language. As far as the time frame goes, the rule requires reasonably prompt timeframes for conclusion of the grievance process, including reasonably prompt timeframes for filing and resolving appeals, and for informal resolution processes if the recipient offers that informal resolution process. And a process that allows for the temporary delay of the grievance process or limited extension timeframe for good cause with written notice to the complainant and respondent of the delay or extension and the reasons for the action. And in previous guidance, they did suggest that campuses finish the grievance process within 60 days, but that time frame was never mandated. And they said because complex investigations with multiple reporting parties or multiple reported parties may take more time than that. However, what's unclear in the rule is what would or would not constitute a reasonably prompt time frame. Another issue I just want to highlight is the presumption of innocence. Under a school's grievance procedures, the respondent must be presumed to be not responsible, so that a finding of a responsibility only comes at the conclusion of the grievance process. This isn't a specific rule change, but rather it was an assumption that parties would be treated equitably during the process. Mandatory and discretionary dismissals. So earlier when I was saying that this is a low bar and you could go above it, however, the mandatory dismissals are mandated. So under those new rules, a school must dismiss a complaint if it doesn't meet that new definition of sexual harassment, if it alleges sexual harassment that did not occur in the school's program or activity, and if it alleges sexual harassment that did not occur in the United States. One of the really talked about provisions was whether or not it would include study abroad. Over the last 2 years, we discussed that with a lot of stakeholders, and I know folks discussed it in their meetings with the education department. But ultimately, they did decide that you had to be in the United States. Under the new rules, a school may dismiss a complaint if the complainant informs the Title IX coordinator that they wish to withdraw some or all of the allegations, if the respondent is no longer enrolled or employed by the school, and if circumstances prevent the school from getting sufficient evidence to reach determination about the allegations. So I should just note here that once a complaint is filed and the formal complaint process begins, if the respondent then drops out of school or transfers schools, then the institution may just dismiss the complaint at that point. And then that third point, if circumstances prevent the school from getting sufficient evidence, if the respondent does not respond or any of the parties choose not to comply with the investigation, the school could just dismiss the complaint. So those are pretty big issues. Another issue is mediation, informal resolution. This was heavily talked about as well. Schools cannot compel parties to participate in an informal resolution process and can't offer it unless there is also a formal complaint. Mediation or informal resolution cannot be used when there's an allegation between employee and student. Parties have to voluntarily consent to the process, and that must be written consent. In any time prior to agreeing to a resolution, either party may withdraw from the process and resume with the formal complaint process. Previous guidance, again, that wasn't statutory, just guidance, held that mediation was not appropriate, even if voluntary. What is unclear about this is that the rule uses broad language around the facilitator of an informal process and who could serve in that role. The live hearing requirement. So we have some schools in North Carolina that do not have live hearings, and this new rule requires that campuses have a live hearing unless parties have agreed to that informal resolution process. And the decision maker in the live hearing cannot be their Title IX coordinator or the investigator. It says, quote, at the request of either party, the recipient must provide for the live hearing to occur with the parties located in separate rooms, with technology enabling the decision maker and parties to simultaneously see and hear the party or witness answering questions. This requirement does not extend to K-12, but as I'm sure y'all are aware of using Zoom for everything, that would be an option for this. And it is a change from previous guidance. It didn't require those live hearings. Again, it is unclear other guidance on the decision makers for this process. Cross-examination is, I think, one of the top 3 things that folks talk about when they talk about the proposed rules. The previous guidance from 2011 and 2014 discouraged cross-examination by the parties during a hearing. The rules say the decision maker must permit each party's advisor to ask the other party and any witnesses all relevant questions and follow-up questions, including those challenging credibility. Such cross-examination at the live hearing must be conducted directly, orally, and in real time by the party's advisor of choice and never by a party personally. And I've highlighted what I think is important in that. If a party does not have an advisor, this is also an obligation of the school to provide an advisor free of charge for the purposes of cross-examination. Again, it does say that only relevant cross-examination and other questions may be asked of a party or witness. And questions and evidence about the complainant's prior sexual predisposition or prior sexual behavior are not relevant unless such questions and evidence are offered to prove that someone other than the respondent committed the conduct alleged by the complainant, or if questions and evidence concern specific incidents of the complainant's prior sexual behavior with respect to the respondent and are offered to group consent. And a lot of folks already have something very similar to that in their Title IX policies. It is unclear, and there may be discretion for schools to decide how many advisors a party is entitled to have in the hearing. I know a lot of North Carolina institutions say that you may have one advisor and one advocate or support person, so that is up to the school. I also do want to note that, again, in 2011 and 2014, all the guidance did was discourage cross-examination, and this explicitly prevents that. So I do think that that is a good improvement in the rule. Another issue is appeal. The appeal process. The rule states that a school must offer both parties an appeal from a determination regarding responsibility and from a school's dismissal of a formal complaint or any allegations therein on the following basis: procedural irregularity that affected the outcome, new evidence that was not reasonably available at the time the determination regarding responsibility or dismissal was made, or that could affect the outcome, the Title IX coordinator, investigator, or decision maker had a conflict of interest or bias. And so previous guidance recommended the schools provided an appeal process, but did not outline what that process needed to look like. And this does have those 3 bases. And again, I'm sure a lot of your school policy already includes something similar to this, but this is the language that the federal government provided. Retaliation. The rule explicitly prohibits retaliation, stating that, quote, no person shall intimidate, threaten, coerce, or discriminate against any individual for the purpose of interfering with any right or privilege secured by Title IX, or because an individual has made a report or complaint, testified, assisted, or participated or refused to participate in any manner in the investigation, proceeding, or hearing. There is specific new language that states, quote, charges against an individual for code of conduct violations that do not involve sex discrimination or sexual harassment, but arise out of the same facts or discrimination or report or formal complaint of sexual harassment for the purposes of interfering with any right or privilege secured by Title IX does constitute retaliation. It does note that a false statement made in bad faith is not retaliation, and specifically clarifies that the exercise of rights under the First Amendment does not constitute retaliation. So if there is a case where the respondent then begins to talk about the respondent during the process, that does not constitute retaliation. Some issues that are not addressed within the rules, they don't address a uniform definition for consent. That's something that I think a lot of campuses already have what they have defined consent as, And so you could maintain that same standard or change that up. And it doesn't include specific training for those involved in the process beyond training on the definition of sexual harassment, the scope of the school's education program or activity, how to conduct an investigation and grievance process, and how to serve impartially. So what that training looks like for each school is not addressed within the rule. This is a little chart I made. I'll just give you a second to look over this. And this is just a process chart, not about any substantive measures, but kind of the process for the start, dismissal, and then conclusion of the Title IX process. I'll just leave this chart up while I see what the chats are. We're about to move into just like an open discussion. Any questions, discussion, please send in questions. If you have specific questions about the rules, I'm happy to go through them in more detail if there's a section that you'd like to have covered. So just drop that in the chat.
So thank you so much, Sky, for walking us through a lot of those shifts and things that we should be considering and thinking about. What are questions that folks have, need more information on while we're still together about some of the shifts that we all just learned about in regards to Title IX, and how you think these things particularly might be impact your campuses? Thank you, Lee. Does the new rule effectively eliminate responsible employees as responsible employee is currently defined?
Right. So that's a great question. And that is unclear in the rule. It does allow for schools to decide who those folks are. So it doesn't say that they have to be these specific folks, but let me pull up that specific language. Now I can't find it, but it does state that schools will have that flexibility to decide who those folks are. So it doesn't, except for those who could make a determination or take corrective actions, those people will automatically trigger that complaint process.
Scott, can you walk us a little bit through the religious exemption and what that kind of could look like? I know we do have a couple schools tied to religious institutions on the phone. Just want to make sure we have a point of clarity about that. And please continue to fill the chat up with any questions you may have. That was a really good one, Lee. Thank you.
Sure. So as far as the religious exemption goes, like I said, a school can submit that exemption at any time. So if a school decides they don't want to submit that exemption now, and really there's no reason to submit your exemption to the education department until there is some sort of investigation into the school, and then you may raise that exemption. But it does include that the school has to first have their highest ranking official sign off on that when it is submitted to the department, and that they can raise that at any time. So it could be, and it also has a specific tenet of the religious organization that has to be claimed. So whether that be a school has a religious exemption or they have asserted that to students and then raise it to the education department. When they do raise that to the education department, they have to say what that tenet is of the religious organization that conflicts with the provisions. And so an example of that would just be LGBTQ. If the religious organization does not believe that, then they could submit that and potentially not provide the same services to same-sex couples as opposite-sex couples. So that would just be an example.
Oh, here's another good one about the religious exemption. Is it for schools that are controlled by a religious organization, not just affiliated, correct?
I cannot say that specifically, that I know the exact language of the religious exemption, control or affiliated. I believe it is broader than controlled, but I'm trying to pull that up in I don't have the language in front of me. I don't want to say one way or the other.
But we will.
Yes, I'm happy to follow up.
Absolutely, absolutely. And we'll share that back out with folks. That we had a question about if the slides are going to be shared. Absolutely. We do have this Title IX webinar saved and recorded on NCCASA's YouTube page, if I'm not mistaken. Other questions? Are there any immediate needs that you are thinking, this is a lot, we're going to need some help on this thing? Please let us know what that thing is in the chat so we can continue to have broader conversations about it and figure out ways in which to support you all.
Just as a follow-up to Lee's question, it does say, I see your question about Shaw is funded, endorsed by the Baptist Convention. We are not religious affiliated. It is put, the headline as educational institutions controlled by religious organizations. So that control word is there. But in the actual text, it does not say it has to be controlled at a specific level or what that control looks like. Yeah, and as I said earlier, I'm happy to talk with you about your specific policy and how you can work on, making that compliant. And if you want to go above the bar or really show students that you want to protect them and take care of them, we can do that as well. I see that Dr. Williams said that he envisions needing help with the training of panel members, facilitators, investigators, and now advisors. Yeah, so that's a really important point. And also just to note that that information has to be publicly available. So what that training looks like, I would recommend that if you're going to have folks that are doing training and they're putting up slides, just to leave those kind of broad. And that's for the campus's sake. so that you don't have to put every single thing out publicly. But I know that that is going to be a big bar for universities to make that information publicly available. And I think Tracy put her email in the chat if you want to contact her about Campus Consortium, or if you want training on your campus. I think my email is here as well. Feel free to reach out to either of us. As far as what we provide to campuses, like I said, we're happy to do training, and we do provide that legal counsel to campuses. I have worked with some campuses on their policies now. We do have a best practice policy that we're willing to provide to campuses if you want to look at what that template language looks like. And so we have that we've developed after polling all North Carolina institutions, looking at what's good or maybe could be improved about each campus's policy. And then we looked at no contact orders as well to see what that best policy, best practice around the no contact orders would be. So we have all of that as just a resource to campuses if that's something you're interested in. And again, we provide free legal training or legal representation to campuses for complainants. Yes, I see some folks saying, yes, they want to get that information. Gabriella, is it possible for you to send me the chat so I can have these emails?
Yeah, of course.
Thank you.
Yes, keep asking away. What are other things that folks think they could possibly need, especially with the new school year looming and things might look a little different? Absolutely. Yes, you asked for it, Ms. Ellison, and you have it. Scott put together some talking points last week, so we'll just make sure that all those things are included in the follow-up with this webinar, so that you all can continue to access this when you need it, as well as sharing it back with others on campus who also may need it too. And please, at any time in which you have additional questions, please do not hesitate to reach out to us. Other questions before we wrap up our time together?
Just to piggyback off of that, the sheet that I created does have, it's a chart that includes those top line items and then what the proposed guidelines, proposed regulations require and what previous guidance was. So you can kind of use that just to compare to your policy and see where you may need to make some changes.
Thank you so much. We'll make sure you get those things. Other questions, things we want to kind of discuss before we wrap up our time together?
We really appreciate y'all taking the time to go through this with us. And again, we want to be a resource. We want to work in collaboration with you. So please reach out to us. We are happy to start a dialogue and give you that support that you're looking for.
Ooh.
Do you want to speak to this, Tracy? Or you want me?
Ooh, Camille, they are chilling. I just know that each of you have just been working so hard in multiple ways around you know, survivor focused, just work in a number of ways. And this just makes that work that much more harder or look different. So that's what I'm really nervous about. I'm thinking about, you know, each HBCU's work on lifting up this issue, and now the significant shifts that are happening with this law and regulation. So that's what I'm a little anxious about. I would be remiss if I did not say I was not anxious about those things, but you know, and I just know that those things also have just a different bandwidth on HBCUs. It will enforce the code of silence in our culture. Yep. And you all have worked so hard. Like, I just know all of the work that all of your campuses have done in turning around and lifting up the programming you have been able to provide, the support for survivors. So those are the things that I'm thinking about. And that's why we wanted to make sure this space was solely for you all to talk about those things around, you know, the impact it could potentially have on campuses. And so those are the things I'm sitting with. I'm sad I won't be able to see y'all. Like I miss, you know, campuses so much. So like, it's just all those things together. And so, yeah, other thoughts around impact on your respective campuses that folks might want to lift up? Because this will help us figure out as your coalition, like how to just continue to support the work that you all are doing as advocates. You all have bandwidths of, you know, you also have the bandwidth where you all have a lot of student advocates who are also engaged as well too. So, you know, any way that we can be supportive to that, please let us know. Changing policy is hard and definitions. See, Camille, you got me on my anxieties now. But training for new advocates. We can talk about some specifics. I had this question asked the other day. We can ask some specifics, but a lot of NCCASA's fundamental pieces around training have been moved online, and those things are available to our membership. I think most of you are members of NCCASA. If not, we can figure out how to drop that information in the chat box and make sure you can get connected with those things. But if you have other things specifically, we can definitely talk about. But a lot of our fundamental one-on-one pieces around the work and how NCCASA approaches its work is available online to our membership. But if you have specifics, please let us know. No apologies, Camille, at all. Thank you so much, Ms. Wanda. Thank you. Thank you so much, everybody, for, let me see, any questions? Let's see. There we go. Training request, please let Gabriella know. A round of applause. Thank you so much, Sky, for such I learned something different every time we talk about Title IX. And I appreciate you for sharing your time with us. Again, thank you all so much for joining us today. We'll follow up with those documents as well as copies of the presentation and our contact information. If you need anything, please don't hesitate to contact us. Everybody, please take care and stay safe and have a good one. Goodbye.